SEC versus Ripple. SEC filed a lawsuit against Ripple Labs in 2020. Ripple Labs responded to the lawsuit in 2021. SEC's lawsuit led to a significant drop in XRP price. In November of 2021, Ripple filed a Freedom of Information Act (FYA) lawsuit against the SEC. This legal battle is still ongoing in 2024. Here's everything you need to know about the lawsuit. The legal battle between the U.S. Securities and Exchange Commission (SEC) and Ripple Labs, the company behind the cryptocurrency XRP, has been ongoing for several years. Here's a timeline of key events. Let's start in 2012. So Ripple Labs is founded and the XRP is created as a digital asset to facilitate cross-border payments. After about 8 years, the legal battle begins. On December 2020, the SEC files a lawsuit against Ripple Labs and two of its executives, Chris Larsen and Bart Garlinghouse, alleging that they conducted unregistered securities offering worth $1.3 billion through the sale of XRP. January 2021, Ripple Labs responds to the lawsuit denying the SEC's allegations and arguing that XRP is not a security but rather a currency or digital asset. 2 months later, March 2021. Unfortunately, the SEC's lawsuit led to a significant drop in the price of XRP as many cryptocurrency exchanges delisted or suspended trading of the token due to regulatory concerns. A month later, and Ripple Labs filed a motion to dismiss the SEC's lawsuit, claiming that the SEC failed to provide fair notice that its sales of XRP constituted violations of securities laws. In May of 2021, the SEC filed a motion to strike Ripple's fair notice defense, arguing that Ripple's executives were aware of the legal risks associated with XRP and therefore could not claim a lack of fair notice. In August of the same year, the court denied the SEC's motions to strike Ripple's fair notice defense, allowing Ripple to proceed with its defense strategy. In November of the same year, Ripple filed a Freedom of Information Act (FYA) lawsuit against the SEC, seeking access to documents and communication related to the SEC's internal discussions about cryptocurrencies, including Bitcoin and Ethereum. The year ends with the court granting Ripple's request to access internal SEC documents related to cryptocurrencies, potentially providing Ripple with valuable evidence for its defense. The year 2022 begins with Ripple filing a motion to compel the SEC to produce documents related to Bitcoin and Ethereum, arguing that these documents are relevant to the case and could demonstrate inconsistencies in the SEC's approach to regulating cryptocurrencies. In February of the same year, 2022, the court grants Ripple's motion to compel the SEC to produce documents related to Bitcoin and Ethereum, ordering the SEC to hand over the requested records to Ripple. March of 2022, the court schedules a pre-trial conference for June 2022 to discuss the status of the case and any remaining unresolved issues. In September of 2022, both the SEC and Ripple Labs submit their initial motions for summary judgment, marking a significant step in the legal proceedings. The court reviews them and grants a request from the Chamber of Digital Commerce. In December of that year, the SEC and Ripple Labs replies supporting their summary judgment motions were made public. These documents provided additional insight into the parties' legal arguments and responses to the opposing parties' motion. The SEC then applies to prevent the release of the Hinman documents in the XRP lawsuit, including any references to them in court papers submitted by Ripple Labs. Let's move now to 2023. In May of 2023, the legal battle between the SEC and Ripple Labs continues, with both parties preparing their arguments for trial and engaging in discovery proceedings to gather evidence. The outcome of the case will have significant implications of the regulation of cryptocurrencies in the United States and the classification of digital assets like XRP. July 13th of 2023, Judge Annalisa Torres issues a summary judgment decision in SEC versus Ripple Labs, holding that Ripple's sales of XRP through secondary trading platforms did not constitute securities transactions, while its direct sales to institutional investors did. Following Judge Torres' summary judgment decision, on August 18th, the SEC moved for an interlocutory appeal to challenge the court's holding. On October 19th, following Judge Torres's denial of interlocutory appeal, the SEC voluntarily dismisses its claims against the individual defendants, eliminating the need for a trial and leaving damages and remedies determinations before a final judgment is entered. Over to now, 2024. Let's start with March. The SEC is seeking fines and penalties totaling of $2 billion in its case against Ripple Labs over sales in the cryptocurrency XRP. In April, Consensus filed a lawsuit against the SEC. Over to May, what we're waiting for now. So the redacted and public version of the data is supposed to be presented by May 8th. Before that, both parties should meet and confer to identify redactions sought by each side. May 13th is also a big day because the two parties are set to file omnibus letter motions to seal all materials relating to the remedies briefings, such as documents, declarations, and supporting exhibits. And a week after that, they are required to file letter briefs opposing omnibus letter motions to seal. Will this finally be the end of the 3-year-long battle? Keep watching CoinGate TV for these and more.